56191. All of them the state of Texas versus Jesse G. Perales. You have identified yourself as the person who has charges against him under those four numbers. Is that correct?
So says the state of Texas.
All righty. Ms. Gonzalez.
Yes, Your Honor.
What is the purpose of our hearings today?
Yes, Your Honor. I have been originally. Hey, Jesse, can you put yourself on mute so we don't get the background noise until I call you if I need to call you as a witness?
Yes, ma'am. Bear with me. I'm just trying to.
You just move the cursor over to, it should be on the
I got it.
left-hand side. You got it?
I got it. Yes.
Thank you, Jesse. Okay, Your Honor, I apologize for that. So I have been appointed to Mr. Perales when he was arrested this fall for two offenses of burglary of criminal trespass and failure to ID. At that point in time, I was only able to get limited contact with him, I believe, for a bond hearing. It was very, very brief. However, I did reach out to his family. Furthermore, he was given a PR bond, and I'd spoken with the pretrial service officer that was assigned to his case, and I was able to gather a little bit of information about his mental health status. Mr. Perales never reported in for anything, and then he later picked up the two new charges that are before the court, where he has the 4 charges. I attempted to schedule a couple of jail visits with him so I can be able to discuss what's going on with his cases. One of which was delayed because of the snowstorm. I was not able to sign in for no internet connection, but with one of the other jail visits that I'd scheduled, he was not able to make, and what was reported to me by the jail staff was that he was having either difficulties logging on or for whatever reason, between all of the information I received from the police reports, from the conversations with his family, and from the pretrial services and from the jail staff, I had reason to believe that my client needed to be evaluated for competency, which is where I filed those 4 motions that were granted by the court for those evaluations. However, since then, I have been able to meet with Jesse. We had a very fruitful conversation about the charges against him, which he does understand. The evidence that is against him, again, that he understands my role, the role of the prosecutors, and the role of the court, and he does understand the system. So because of that understanding, I now believe that the evaluations are unnecessary and would create an additional delay for my client. So I requested this hearing for today so we can go ahead and put it all on the record, and I can withdraw those motions so that way we can proceed through the regular course of the criminal justice system.
Okay. Mr. Perales, please raise your right hand, sir. You solemnly swear that in this proceeding, any answers, any information or responses you give will be the truth and nothing but the truth.
So help me God, Your Honor.
Thank you. You may put your hand down. All right. Mr. Perales, first, before I say anything else or ask you any other questions, just for the record, you understand you have the right to remain silent. That means you do not have to say anything. You don't have to answer questions. You understand that?
I fully understand, Your Honor.
And in this particular instance, this is limited. The few questions that I have is limited to the issue of competency and nothing else. You understand that?
Again, once more, fully understand, Your Honor.
All right. How old are you, sir?
On paper, 39 years old. 1981 is going to be the date of birth.
All right. And do you have family?
I do, Your Honor. There are 6 of us, and I am going to be the 5th child.
I'm sorry, say that again.
There are 6 of us in the family. I am the 5th born.
All right. Well, what I had reference to, do you have any dependent children?
Oh, I'm very sorry, sir. I have twin girls and a son with A little girl. She's about 23 years old, I believe.
So you got a total of 4 children?
Yes, sir.
All right. And up till now, how have you been employed?
I teach the gospel, Your Honor. I've stopped working approximately about 4 years ago. And I have found myself on the street for the remaining, well, about 4 years ago. I've been without work. And as I mentioned to you, much like on this Zoom of a meeting, I teach the gospel on Facebook, YouTube, application called live.me, as a matter of fact, wherever I can get
Excuse me, the application called what?
live.me. This is going to be a Chinese application through the CEO of Yuki He. And I've been doing that for quite some time, approximately going about 2.5 years. And it's a monetary application, as a matter of fact. And I've never been paid for that monetary application. As a matter of fact, San Antonio knows all about it. They filled up a Via bus. I'm not too sure if y'all guys know the company Via is going to be our metro system, with a whole bunch of live.me people, and decorated the city, as a matter of fact, with the logo and the emblem and the colors of said application.
All right. Mr. Perales, where are you right this moment?
I'm in the Bexar County Jail on the 4th floor, sir. Left side, 26 is going to be the cell, and it's going to be on top.
Okay. Where were you born?
San Antonio, Texas, Floyd Crow Drive, and that is going to be the University Hospital.
All right.
Mentioned on
Now,
paper.
do you know Jessica Gonzalez?
She is my beautiful attorney there, and I have had the pleasure of meeting with her. A very witty and smart woman there.
All right. And who is the sheriff of Bexar County?
It's going to be Mr. It used to be.
That's all right.
I'm very sorry about that.
His first name's Javier.
Salazar is going to be.
There you go. All right.
Yes.
All right. It sounds and it appears to me that you pretty well know what's going on.
Of course.
I am concerned, and I make this only as a comment, but it's not necessary. I want you to hear it. I am concerned that you're telling me that you preach the word, yet you're being held on 5 different violations of the law. I don't want a response. You have among them burglary of vehicles, which ordinarily is something that's charged against people that are trying to make money for drugs and stuff. Like I said, I don't want a response from you whatsoever. It just bothers me that you're telling me that you're willing to preach the word, but to me, it's a conflict of the two. All right, Ms. Gonzalez, do you have any other questions?
Well, just one, I guess, further issue to address is one of the tip-offs that I do believe my client does understand everything is that like I said, we reviewed the evidence. He was able to provide me.
Mute yourself,
Go ahead,
Mr. Perales, mute yourself. There you go.
Thank you. He was able to provide to me any defenses. He gave me his version of what happened. As we went through, he remembers everything exactly and was able to explain to me the comments and the conversations that went back and forth at both times that he was arrested. So that is one of the things that led me to believe that he is not incompetent and he is ready to proceed. Furthermore, I did reach out to the prosecutor for a plea offer. I explained to my client the plea offer, the terms of the plea offer, all of the constitutional rights that go along with it. He was able to engage in that conversation with me, was able to ask me meaningful questions with regard to that, which also leads me to believe he is understanding of the process. We were hoping to be able to work out all 4 of these cases with the plea offer that was given. However, a legal difficulty did come up with the plea offer where my client wanted to be able to request a shorter time with reasons why he wanted to be able to request a shorter time. And the prosecutor refused to allow him to go open to the court and explain the reasons for requesting a lower time to the court. again, leads me to believe that my client does fully understand and can engage with me in order to prepare for any defenses for his case.
Very good. Uh, The court, Mr. Edelman,
Yes, sir.
what says the state?
On what issue or topic, sir?
On the comments, explanations, responses that have been placed before you and this court, both comments and explanations by Mr. Perales as well as Ms. Jessica Gonzalez, his defense attorney. The issue being, I have issued orders for psychological evaluations, and the request now before the court is to rescind that order, and Ms. Gonzalez wishes to withdraw that motion.
I think that there is a distinction between the issue of whether Mr. Perales is competent to stand trial and whether psychiatric evaluation would assist us in better understanding his mental state, and whether there are any specific actions or programs that we can use that would allow us to assist him if possible.
That's
Your
more
Honor,
excuse me, that's more in the sense of a risk and needs assessment. That's separate and apart from the issue of should the court have an order for psychological evaluation, primarily competency to stand trial. Anything else, Mr. Edelman?
No, sir.
Okay. The court's going to rescind the order for psychological, for competency evaluation on Mr. Perales. I would obviously, as the court, at all times retain the authority to issue another order for evaluation, not necessarily limited to the issue of competency. But for right now, that order will be rescinded. Anything else today, Ms. Gonzalez?
yes, now that that order has been rescinded and we no longer have to wait for competency, I would like this case or the cases to be placed for immediate bench trial setting. I'm ready to go this afternoon for a bench trial. My client will be pleading guilty to the offense that he is charged with, and he would like to go open to the court in order to ask for a time served, judgment satisfied sentence, given all of the credit that he does have in custody while he's been waiting for these matters.
You'll be pleading guilty to what?
Whichever court or whichever case the prosecutors are going to go on right now, I believe the ones that are filed are going to be the failure to ID and the criminal trespass, Your Honor.
I'm not aware that they're set for trial today, Ms. Gonzalez.
Right, that's what I'm asking for, is now that the order has been withdrawn, I can now proceed to ask for
Okay,
a setting.
you're requesting it. Okay, I
Yes,
got
Your
you.
Honor.
All
And I'm
right,
saying I'm ready today to be able to do it.
I hear you.
Gotcha.
I don't think this, well, I'm not going to speak for them. State, are you ready to proceed today on a bench trial?
No, Your Honor.
I didn't think you would be. But in fairness to defense, since they're requesting it, I thought you should answer that. All right. Patty, how soon can we set this for a, well, wait. State. Is the state consenting to a bench trial?
It is not.
And Your Honor, I'm prepared to be able to argue against that with the most recent emergency order that was actually just filed by the Supreme Court on Friday. It does allow for the court to not require the state to consent to a bench trial. And if you like, I can go ahead and share the order with you, and as well as the language that I am referring to that specifically states that the consent is not needed, with the fact that absent any constitutional limitations, the court no longer can actually put on hold the statutory requirements, which the state going to demanding a jury trial is a statutory requirement. Furthermore, there's a case out of the Houston Court of Appeals that specifically addresses this issue.
And that's fairly recent, obviously.
Oh, obviously, yes, Your Honor.
Judge,
Yes.
if I may, the Mr. Perales has a total of 4 cases, 2 of which have court files and 2 do not.
Correct.
So those are the ones you're referring to, Ms. Gonzalez?
Correct. The 2 that have the court files.
All right. Now, have you conferred with the state?
Yes, Your Honor, I have.
Okay. Patty, give us a date. And by the way, I do want to review that latest story. I thought I had read some of it, and not all of it, apparently.
I was going to say, would you like my marked up copy? Because I read it yesterday and
I don't care. I don't care if it's marked up or not, as long as it's legible, or rather that I can read it.
I will send it to the prosecutor and to the court, so it wouldn't be considered an ex parte conversation. But I will also send the court in re aug, which is also a recent Court of Appeals opinion that actually upheld the position that the trial court can suspend the Texas Code of Criminal Procedure provision that allows the state, or that requires the court and the state's approval to a defendant's jury trial waiver.
Okie dokie.
Are you referring to the Court of Criminal Appeals decision that was released on March 3rd?
For which one? For in re aug or for the Supreme Court orders?
For in re aug.
Okay, I don't have that in front of me. Do you have that?
I do, and it is from the Court of Criminal Appeals and stands for exactly the opposite assertion that you're making.
Okay, so if you can send me that.
And to me.
And to the judge, I'll start the chain, unless Andrew, if you already have it up.
I actually do have it up. I'm sending it to each of you now. Sent. You should each receive it soon.
I always like that. We should each receive it soon.
Should. I can't guarantee that you actually will.
I did not, but maybe with the second refresh.
It'll be a moment, I'm sure.
You don't want to share it on the screen, Andrew?
If you'll allow me.
Yes, it has multiple.
It's up. Well, I mean, the share screen is up.
There we are.
So I think the most salient sentence is right in the middle. The judge simply does not have the authority to conduct a bench trial when the state has not consented. He cannot use the emergency orders authorization to modify or suspend procedures to confer that authority upon himself.
So I'll go ahead and file the speedy trial, Your Honor, on both those 2 cases. If the court's not going to give me a bench trial setting, I'll go ahead and draft up a speedy trial.
That's Obviously, your call.
Patty, do you want to wait for me to file those? I can have them filed by this afternoon. Or can we just get a date now?
Do you want me to go ahead and schedule it for Tuesday, March 16th?
Yeah, I can do. In fact, he's on my calendar that day already. Do you want to do it in the morning or the afternoon?
I think the afternoons are better.
Okay.
So it'll be 1:30.
Patty,
Yes, sir.
the accurate statement is that afternoons are gooder.
Okay.
All right,
I will have those drafted and filed, Your Honor.
Mr. Edelman, thank you for sharing that.
Now, Your
What was
Honor.
the site? Because I didn't see the site on it.
It was,
It should be in your inbox now. I just got it, and I'll add it to my CLE for tomorrow.
Yeah, but see, I'm using county stuff. Mine has still not gotten it.
Oh, really?
Right.
in the Court of Criminal Appeals, number WR-91, 936-01.
Okay, was that an appeal of OG or what?
It was, sir.
Okay. Interesting. The governor can cause all kinds of suspensions of rights and constitutional protections, but the courts that handle them cannot.
Correct, Your Honor, which is why I want to read the full opinion and see exactly how
Okie
they
dokie.
married the two together. And I will be prepared to argue it at the speedy trial hearing on Tuesday.
Very good. Anything else on this matter?
Not on this matter. Does the court need me to file anything to be able to withdraw that the competency evaluation orders?
It'd be good to have a written order that just specifically and briefly says that.
Okay. Well, I mean, does Linda have something there? Or I'm imagining you're in your chambers. Does Linda have something that she can put it in writing, or do we need an email?
I don't think she does.
Judge, I'll
with
just,
us, okay?
she's not with us because she's at lunch. All this week she's going at 1 o'clock.
Okay.
But I can email her and let her know what happened.
Well, it's important that she gets an order right away. Jessica, just send her, just Ms. Flores, a simple order that says the court hereby withdraws the order of requiring a mental health evaluation / competency evaluation.
Okay. And I'll
And that was
follow up with
applicable-
Linda.
That was applicable to only 2 cases, right? Because the other 2 have not even been filed technically.
I did it on all 4, and from when I looked in the system, it was granted on all 4.
Okay, now, do we have actual files on 2 of them?
Yes, there's files on 2 and
On
no
2.
files on 2.
That's what I'm talking about. Okay, well, we'll just put the orders in there, and that way there will be no glitch and he gets held longer than he should be. All right. Then if that's it, anything further, Mr. Edelman?
Yes. The state's position was that if Mr. Perales wanted to go open to the court on the issue of the length of his sentence, the state would not allow it under the plea offer then in effect. That is not true if the defendant wants to plead on all of his cases. So if it's his desire to plead guilty or no contest on each of them, assuming that they've all been filed, then the state will not make any statements one way or another about what constitutes an appropriate punishment.
Well, Your Honor, that's different than what was told to me. What was said to me in the email was when I asked about whether or not he can go open if the time was going to go up, the answer was no, because I will not allow him to go open. He can accept the offer or he can go to trial. which is why I'm requesting a trial on the cases. That was
Well,
those were
tell
the
you
only
what.
options.
I'm gonna put the state and defense attorneys in breakout. Let y'all make whatever positions each of you has very clear to each other, and then we'll meet Tuesday and decide where we're going. Period. Okay.
Okay. And Your
Yeah.
Honor, if Jesse can be excused, and I will, after I speak with the attorneys, I will come and visit with him. And if there is an updated offer, I will pass along the updated offer to him and see if he'll accept it and notify the court by Tuesday. So that way we know if we can either plea or if we're going to have a speedy trial hearing on Tuesday.
Your Honor, one
Yeah.
more thing, just to let the court know, everybody know, the 2 files that there are no files created yet for are the ones that Mr. Perales is in custody and being held at the Bexar County Jail for. And those are the ones that Ms. Gonzalez wants to file the motions for speedy trial. So just to let the court know.
No, just for clarification, I was going to file the speedy trials on the 2 cases that have been filed.
Oh, okay.
Yeah.
Thank you.
Yeah, sorry about that.
So now he's being held on the 2 old cases.
No, Your Honor, he
The
is
most
still,
recent.
he is
Okay,
still
due
considered
to the
released.
order for psych eval.
No, Your Honor, he is still he's still granted and released on a PR bond on the criminal trespass and the failure to ID. So he shows on bond for those 2 cases. He's being held in custody on the hindering or interrupting a courtroom proceeding and for the burglary of a vehicle. He was denied PR bonds on those 2 cases. That's why he's being held in custody.
All right. So, Mr. Edelman.
Yes, sir.
What would preclude the court, if anything, to grant him PR bonds on those 2 cases?
I think the Executive Order 13's language would probably preclude those actions.
Which part?
The granting of PR bonds for the purpose of achieving the physical release of the defendant.
But not all PR bonds are canceled, just certain PR bonds. And his cases do not qualify him under holding him and denying him PR bonds.
The problem is that I think his prior criminal history probably precludes him.
No, he was granted PR bonds on the first 2 cases.
Well, I need to know if he's, well. All right. Tell me criminal history. Is there anything of violence in his criminal history or threats of violence?
I didn't note anything down in my first search originally on December 19th, 2020. He does have some old TDC trips, but if I remember correctly, those were due to drugs, but I have it pulled up. Sorry, it went.
Mr. Edelman, you have access. What if any criminal history does he have? Specifically, anything in the nature of violence or allegations of violence?
Assault and bodily injury alleged to have occurred June 14th, 2009, that was dismissed for missing or uncooperative witness. Depending on how one defines violence, resisting arrest alleged to have occurred on September 5th of 2007, for which Mr. Perales was convicted. Deadly conduct arising out of the same criminal episode. Felon in possession of a firearm. That'd seem to be all, Your Honor.
And I would disagree that disqualifies him under the governor's order Furthermore, he, like, as I already stated, back in December, he was granted PR bonds on the criminal trespass and the failure to ID. So it's already gone through another judge or magistrate that's reviewed that exact same criminal history and granted him PR bonds.
The only problem with that, quite bluntly, is that I have previously ruled that resisting arrest by itself, to me, is an act of violence. Now, how serious it is, or whether it's certainly not 3G, I clearly know that.
Right, but
But it is a
resisting
misdemeanor in the nature of having used force against a peace officer. That to me is a violent act. That's been
But
my previous rulings.
Right, but under resisting arrest, search, or transportation without knowing any additional information, resisting arrest can be being in the patrol car and not cooperating in a patrol car. And I've actually tried and convicted a person based off of those facts alone. So without a police report for the court to refer to, you're making assumptions that we don't know about and holding a client in custody when he's unable to afford or post any bond, which affects his constitutional rights.
Well, then we'll wait till Tuesday to find out what the specific facts are and what the reports indicate, if any.
If any.
All right. Then we will see each other, God willing, on Tuesday afternoon in accordance with whatever time Ms. Garcia gives us notice of.
Thank
All
you, Your
right.
Honor. And if Jesse can be excused, then I'll go into a breakout room with the prosecutors.
Very good.
Your Honor,
Ma'am,
just to let you know, Ms. Flores is with us now.
all right. Ms. Flores, on the matters involving Mr. Perales, I am rescinding the order / withdrawing the order requiring a psychological evaluation. Okay,
Okay,
I want that to take effect immediately.
okay, I will let them know.
All right, there will be an order sent to you by Ms. Gonzalez. It should be quite brief, quite simple.
Okay,
All ready?
all righty.
Thank you, ma'am.
You're welcome.
Ms. Gonzalez, I can go ahead and excuse Mr. Perales?
Yes, and I will meet with him. Once I speak to the prosecutors, I'll schedule a jail visit and I'll go over the new plea offer if there is one with him.
Okay.
All righty. Then everybody's excused.